So that's the compliance piece. Now, there are two exemptions. In fact, there are 23 exemptions under the Corporate Transparency Act. And if you were to do a deep dive into the 99 pages and the rest of the statute, which I hope you don't, I've done it for you, so you don't have to. But there are two possible exemptions that can apply to clients of my law firm, and we've figured this out. One is there are some community associations that are 501c4 tax exempt. This is not 501c3 tax exempt. That's churches and charities, Boys and Girls Club, Goodwill Industries. You're not 501c3. 501c4 is a community service organization. There are very few of them in Arizona, but there's an off chance that one of you could be a 501c4. You're exempt. And the reason behind the exemptions is that if you read through the 23 of them, I'm not suggesting you do it, but if you were to, and what we've figured out, and there have been lawyers who've written about this, is that in each of the 23 cases, the assumption is the government has the information anyway from other directions. And the second exemption is a large employer, 20 or more US-based employees, and 5 million or more in gross receipts. Well, pretty much by definition, if you're managed by Cadden, you are outsourcing your management and your employee infrastructure, because that's the nature of employing a professional community management company. So it's going to be difficult for our clients, my law firm's clients, that are professionally managed to fit into the large employer exemption. Now, I do have a number of clients that have direct employees. You might be aware of the Robeson active adult 55 plus communities down in Green Valley area, Robeson Ranch, the Sun Lakes communities in Chandler, Pebble Creek up near Goodyear and Buckeye. Those communities tend to have large direct employees employed directly by the association. And in some cases, because of the size of the golf and the food and beverage operation, they have $5 million or more in gross receipts. But if those employees are employed by a management entity, if it's wholly owned by the developer, then they wouldn't fit the large employer exemption. So there's not much room in the large employer exemption, especially if you're professionally managed by Cadden Community Management. So it's really a footnote here and likely inapplicable. So what are the Yes,
Jeff.
Quick.
I had a couple of questions if we can go real quick. So one says, wouldn't it make more sense to comply by simply providing a list of the board members instead of just the president annually, since all board members are making decisions?
That's an alternative, absolutely. There is room in the regulations, and there will be an opportunity in the portal to list more than one person. And if the board decides to spread the frustration of this entire situation among everyone and not put it all on one person, that would be perfectly fine. That's a decision the board can make. Basically a kind of the childhood game of not it, not me. It's everybody or nobody. And I'll talk to you a minute about the penalties for non-compliance. And Jeff, I can't criticize that alternative method of compliance. And maybe I was trying to be a little too cute here. I'll concede that it seemed easier to me that the president is easier, but if there's a view that it's easier for a board of 5 for all 5 people to upload and register, the government's not going to care. All they care about is that when there's a $20 million drug cartel money laundering operation that somehow makes its way through Del Boca Vista in Tucson, that they can find the humans that are connected to it. And I'm joking. I mean, I intend that to be a joke because this is all sort of ridiculous when you connect it back to money laundering, drug cartels, and counterterrorism, that they want to know who the humans are that are connected to that corporate entity that's engaged in the criminal enterprise. But as long as there are humans with a real passport, a real driver's license, and a residential address that the USPS recognizes as a real address, then we're in compliance. And if the board decides it's everybody or nobody, I can't criticize that, Jeff.
Certainly. And then just one more on that point, and I'll probably hold the rest of the questions to make sure we get through your slides on time here. But this kind of is on the same vein. If the HOA was taken over by a fiduciary because there were no volunteers, would then the fiduciary be the president to report?
I assume that would mean like a receiver?
Yes, like a receivership situation.
You know, it's interesting you say that, Jeff, because having read the 99-page regulations more than once, in fact, probably 3 or 4 times, I don't recall that coming up, but yes, the receiver would be the beneficial owner for the period of the receivership. I believe that would be the case. And during that period, the receiver would have to register.
Very good. Thank you.
Although, we certainly talk about receiverships a good bit, but they don't happen with the frequency that we talk about them. They're serious when they happen. So a couple of complications and opportunities, more complications and opportunities because there's not a lot of opportunities. Okay, so here's a challenge that we see could happen. The portal's not up and running yet. We see a potential possibility that a sophisticated director goes to the portal, grabs Greenacre or Del Boca Vista, signs herself up as the president, does not share the login credentials, resigns in a meeting, grabs her board book, slams it shut, drops 5 F-bombs on the way out and says, I quit, and doesn't share the login credentials, resigns, is removed, dies in office. But the key point of this hypothetical I'm setting up here is she grabbed the registration, and now that corporate entity, Greenacre, Del Boca Vista, is registered, but Sally, the director, has the login credentials and didn't share them. What I'm a little nervous about is the federal government's increasing use of two-factor authentication. There's something that the government's been using called login.gov, where you create a little profile at the government and you have a username and a password, which is old school now, where you have your Gmail account, you have a username and a password, but you can't get past the username and password without the website, in this case, the U.S. government portal, sending a code to your cell phone. And if that's the way the system is going to work, and I'm starting to think it will, because that's the way the U.S. government has pretty much moved completely for identity fraud reasons, that Sally, the director who grabbed the login, cannot just hand over sallyw@gmail.com and a password of 12345 and say, here, I've resigned, here's my login. You can change it within 30 days, because if she set it up with two-factor authentication back to her cell phone, it's going to be difficult. We won't know how to overcome this problem until after the portal is up and running, and even perhaps until after we watch the portal operate for a quarter or 4 months and see exactly how the logins are created, whether it's two-factor authentication, what will happen if Sally, the director, grabs the registration, or if a management company can go grab the registration of all 85 communities. I'm making the number up, 85, however many communities are managed by a particular company, and register them in bulk. We don't actually know any of that yet. So I'm worried I mean, I'm worried professionally in a sense, but I'm concerned that Sally, the director, grabbing the credential on 1/1 and making it, the New Year's celebration. Let's get this over with, because attended a webinar with me, and I made a big deal about this and got the photocopy of the passport all ready to go and memorized a residential address, and Del Boca Vista is all ready to go. And then before you know it, we've got a login that is far away from the association's ongoing governance infrastructure. The other directors don't know about it. Professional management doesn't know about it. And now we're kind of stuck in a land where we can't control it. So what are the penalties for noncompliance? A $10,000 civil penalty and 2 years in prison is the penalty for noncompliance. I had a client ask a while back, or actually say to me, well, we'll just pay the $10,000. We're not participating in any of this. We'd rather pay the $10,000. And my first thought was, my gut instinct was, well, that's really unfair to the fellow homeowners that you're going to use their assessment dollars that have been contributed on the assumption that the assessment dollars have been paid for the pool, for the roofs, for the landscaping, for the common expenses of the community. Those assessments were not paid on the assumption that they're going to be used to pay a civil penalty for board members who decide, based on some personal political bias, and maybe I sound judgmental by saying that, I don't mean to be, but their own political belief that this statute is bad or shouldn't be complied with. And by the way, I'm just the messenger. I'm a lawyer. I preach compliance. I want my clients to not get in trouble. And my first instinct was, that's unfair to foist the $10,000 on your fellow homeowners. And it prompted a discussion of, well, what exactly would happen if we ignore this? What is the likely dance of prosecution? How would that work? I was a political science major in college, and the seminal book about legislation is called The Dance of Legislation, published in 1974. So the dance of prosecution is, here's how it'll work, as I assume. One thing the federal government is extremely good at is sending postcards. And the 32 million business entities are known. They are public databases in all 50 states. And there are a number of websites that are available to the public that aggregate all of these corporate entities. One of them is called opencorporates.com. Another one is Visipedia. There's a wiki website that aggregates all the corporate data. It's not a wild ass guess that there are 32 million corporate entities. There are publicly available websites that you could go to now. Open Corporates, I think, is the best one, but that's just because I, look at these things every once in a while. And the federal government is very good at taking that data, turn it into a giant Excel spreadsheet, and generating postcards. And what they would do is generate a postcard after January 1, 2025. Are you still there? My computer's making noises.
Yes, we're still here.
Okay, I don't know what my noises are. I wish I had been able to shut everything off. So the federal government's very good at generating postcards. So what they would do is, after 1/1/25, when the 12-month window closes, they would generate postcards. They will generate postcards and say, Greenacre, you're out of compliance with the Corporate Transparency Act. We don't have a beneficial owner registration for you. And they would say the same thing to Del Boca Vista if those boards decide we're going to intentionally be out of compliance. And it's not Cadden managed communities I'm concerned about. It's the thousands of volunteer managed communities in Arizona that don't have professional management that are going to be out of compliance most likely. And so the federal government will send a postcard. They will likely send a series of postcards that after some number in the series will end with a strong demand letter from the federal agency, FinCEN, and eventually that series of postcards and final demand letter will end up in a file folder on a U.S. attorney prosecutor's desk. And just like in some old movie or cartoon, that prosecutor's desk will have a stack of folders on the desk, and that prosecutor will work through them one at a time. Look at this file, set it over here. Look at this file, set it over here. And a prosecutorial decision will be made one at a time for every Arizona corporate entity that is out of compliance with the Corporate Transparency Act after the series of postcards and the final demand letter. But in a lot of cases, the original board in place in the year 2024, next calendar year, the window of compliance that made the decision to not comply will not be the board that will be on the receiving end of the postcards and the final demand letter, and will not be the board in place when that U.S. attorney ultimately works through the file folders and makes a prosecutorial decision about the 2 years in prison and the $10,000 civil penalty. My guess is, and I've never done criminal work, by the way, but my guess is that even when the U.S. attorney ends up with a file, he or she will provide every out of compliance business entity with a last chance to register and avoid any civil penalty or prison time. And that's the dance of the civil penalty and prison time prosecutorial decision making. And so for a lot of people, when I explain it that way, they say, well, geez, that's not that big a deal. But as a lawyer, I'm the messenger. This is a law. We have to comply. It's easier to just upload the passport, driver's license, your residential address, and your name. The federal government has all of this information anyway. I'll try to make light of any concerns somebody might have. But if you don't do it, you're leaving a future board to clean up a mess with the U.S. Attorney's Office eventually. And there's an argument that's not fair either. So, trading one perception of unfairness, that why should an HOA in Arizona get caught up in Russian oligarchs and yachts and invasions of Ukraine, that's unfair. We can't meet that unfairness with our own version of unfairness, and just not doing anything about compliance. No judge is going to say, well, you don't have to comply because you're right. You got caught in something that had nothing to do with you. That's not going to work either. So as I said, the portal is not there yet. We do have unanswered questions. We'll know more in January. As we know more, we're dedicated here at Carpenter Hazelwood to supplementing information that we've already provided to Cadden management. We do that on an ongoing basis, part of our commitment to the industry, and we'll continue to do so. I don't expect much more between now and the end of the year. There have been some efforts nationally. Community Associations Institute has been lobbying Congress and certain Congress people to run a bipartisan bill to exempt community associations from these requirements. But as I said earlier, they can't actually argue with a straight face, like the 23 exemptions, that the federal government already has this information. And we can't say that money laundering and criminal activity never happens in community associations. That would be disingenuous. It does. And what I have said, I'll say it to you, is we have a divided Congress, not just the Senate and the House under different party control, but even within party divided. And I was, saying the other day on this topic, I have a hard time seeing Republicans and Democrats having a peaceful moment where they say, there's a lot going on in other countries. We're at war over how much money to give to these foreign countries. We're at war over everything possible in the political spectrum in this country. But let's agree to make peace for a day and exempt community associations from the Corporate Transparency Act. And it feels almost like a joke when I say it, that people would set aside all political differences for even an hour to exempt community associations from the Corporate Transparency Act. And a few months ago, CAI National, Community Associations Institute National, was actually pretty optimistic because a bill was drafted and introduced in Congress to actually do this exemption. And they got a little excited and optimistic. But as I said earlier, the dance of legislation is complicated. Getting a bill passed from both houses through committee and to the president's desk is extremely complicated, and especially in a heightened political environment, it feels almost impossible. And now there's no time. I mean, we're already December 1. We're one month away from compliance, not the deadline, compliance window opening. And frankly, there's no time. I'm not optimistic anything is going to change. So this is happening. And I have thought a good bit about the board doing a resolution to avoid rogue registrations. That's the first bullet point here. We'll call that a rogue registration. That perhaps the board do a resolution indicating how it intends to comply with the Corporate Transparency Act. And I like the premise of the question earlier that perhaps the resolution is we're all going to register as the beneficial owner, or the resolution is the president is going to register as the beneficial owner, or the resolution also saying, or only saying, we're going to have professional management do the registration, or if a director does the registration, the director is going to make sure that the association and professional management have the login credentials so that the corporate entity can remain in compliance over time. There's plenty of things to consider and integrate into a resolution as we move forward, and not looking for associations to spend $5,000 on legal fees to do a simple Corporate Transparency Act resolution, but there is some meat to put on the bones of a board adopted resolution to indicate for each other on the board and for management how you intend to comply with the Corporate Transparency Act. And we may be able to assist Haddon with a suggested format. I've already done one. I think I've sent it over, but the one I did send over was really limited to ensuring that we don't end up with a rogue registration, but it was easy enough to add those additional components that the president's going to do the registration, or all of us on the board are going to do the registration. So these are the complications, and we'll call the opportunity to do a resolution to indicate to each other on the board and to professional management how we're going to comply moving forward. And moving forward, as I've given this more thought, the annual meeting is really the opportunity for the beneficial owner to change, whether it's all five. And I have been talking this evening on the assumption that the board has five members on the board. It could be 3, it could be 5, it could be 7, it could be any number. But I've just been hypotheticalizing a 5-person board for no reason other than it's simple and easy to do. The annual meeting might be the opportunity to revisit this on an annual basis, and there might be some forms that can be developed, and we're happy to help, of course, that after the annual meeting, as soon as you're elected, we might need to get some information and inform candidates of the Corporate Transparency Act and disabuse new candidates or new directors of the notion that serving on the board has no regulatory obligations, and that there's nothing that has to be done other than showing up for some meetings and weighing in on topics that come up from time to time. That there are some regulatory hurdles, regulatory compliance issues that we have to deal with. And so these annual meeting disclosures and forms that we might have to have candidates who are now directors, winning candidates, I should say, fill out, that may become the norm moving forward.